Okay, good morning, everyone. Thanks for joining us this morning to discuss leave administration, as well as some real life scenarios regarding leaves of absence and how to handle them. As I always do when we start these seminars, I invite you to please ask questions. You can either put them on the Q&A or, um, the message bar, and I will get to them. I want to make sure we try to answer everybody's questions that we can. And it'll be a better seminar and more interesting if you ask questions. So please feel free to do so. Also, if you have ideas for future seminars, please don't hesitate to reach out. That's how we get many of our ideas for the seminars is from you folks who are on the front lines and what you're interested in and want to hear about. Before we dive in, and I am Ann Lavelle, I'm the compliance specialist for CTR. I was a practicing attorney that specialized in management side labor and employment for a little over 2 decades. And I retired early so I could spend time with my family. But what I always enjoyed was the training component to what I did and going into employers and providing discrimination, anti-discrimination training, or whatever it might be. So love talking with people, love answering questions. So feel free to ask those questions. Normally, we have a small segment at the beginning of every seminar regarding legislative updates. It's been surprisingly quiet. Maybe everybody was on vacation in August from the government. I don't know, but we don't really have any burning legislative updates to talk about. So we're going to dive straight into the seminar. The other thing that I'm going to just apologize for in advance is normally I do these seminars from CTR's office. Today, I am actually at my house. For 2 years, my family avoided the COVID bug, but unfortunately it hit us this week. And while I am negative, my husband and 2 of my daughters are positive. And for very good reason, CTR did not want to see my little smiling face in the office this week. So I'm doing this from my house. And while I have tried to pick the most quiet room in my house to do this, I do have dogs and obviously kids. So hopefully we will go through this uninterrupted, but should you hear strange noises, rest assured that CTR does not have a couple of crazy dogs in the office or a couple of crazy kids. It is at my house. So let's dive in here. And the way this is set up for today is we're going to talk about leave of absence administration, some do's and don'ts and best practices. And then we're going to talk about some real life scenarios. And the real life scenarios come from when I practiced situations that we actually ran into. I've tweaked them slightly to protect the guilty or the innocent. But we'll work through those and talk about what should have happened from an administration standpoint and how maybe to best handle a situation like these, because they're common. They come up all the time. This is one of the most common conundrums that employers of all sizes face. Okay, so leave administration, like I just said, all sizes of employers face this. It's not just the FMLA employers out there that have this as a conundrum that comes up all the time. Obviously, if you're covered by the Family Medical and Leave Act, you need to know that you're covered by that. And where this usually comes up is employers who just hit the 50 mark, or they've got a lot of part-time employees and they're not sure if they're hitting the 50 mark, or they're just not familiar with the law. And so as a great example of that, I got a call one day from a company that turned out to have 60 employees. And the management was from Germany. And of course, different laws, right? And they had an employee who was requesting time off for a medical procedure. And they had no idea what to do with that. And I said, well, I think you're covered by the FMLA, so let's start there. They didn't know what the FMLA was. So I'm assuming everybody on this call knows what the FMLA is and knows if you're covered or not. If you have a lot of part-time employees, there's a special way to count that. And so you need to know whether or not you're over 50 or not. When you get somebody requesting the leave, that's the wrong time to figure out if you're covered or not. You need to know that before the leave is requested. You also need to be aware of the state and local laws. We've done seminars on these, and all of our seminars, including this one, are recorded. So if you want to go back and listen to something, you can do that. They're on CTR's web. And you can hear about the Allegheny County paid sick leave law, or whatever you want to listen to. We've gone over other FMLA issues. That's a different seminar. We're not going to dive into the nitty gritty of either of those laws right at the moment. We just need to know whether or not we're covered by any of this. The ADA, people look at that as a disability accommodation, but one accommodation is a leave of absence. So if you have 15 or more employees, we know, even if you're not covered by the FMLA, we know that you are covered by the ADA and that a leave of absence may be a reasonable accommodation. And in Pennsylvania, we can take that down even further. You can be an incredibly tiny employer with just 4 employees. And the Pennsylvania Human Relations Act, the PHRA, is going to cover you, and that mirrors the requirements under the ADA. And so you can say, well, gosh, I'm a really tiny employer, and so I've dodged the bullet of the FMLA and the ADA, and maybe even the Allegheny County and Pittsburgh leave laws if you're small enough. And hey, great news, I don't have to do anything. But that's not true. If you have 4 or more employees, you have to look at whether or not you can offer leaves of absences to employees with medical issues or disabilities. You have to look at what your own benefit plans say. If you have short-term disability, long-term disability, and we'll talk about the healthcare plans a little bit later, what they say with respect to how you handle your benefits, whether you put people on leaves, whether you terminate employment, and if so, at what time. And then, of course, there's workers' comp. So in Pennsylvania, workers' comp starts with the first employee. In some states, that's not true. Like Texas, it starts with basically 4 employees. If you have somebody who gets injured on a job, even if you just have 1 employee, you have to look at whether or not a leave of absence is appropriate under the workers' compensation laws as well. And we're going to go into this a little bit more in depth. But that's sort of the laws we're looking at to say, hey, a leave of absence is appropriate, or it's not appropriate, or here's the laws that are covered. Okay. So as we look at this, the other thing we look at is non-mandatory leaves. The prior slide, if we look at that, and I apologize, I've gone 1 slide too many. This slide is the legally mandated leaves that are out there that we have to deal with, or at least the laws that say we need to consider a leave of absence. When we look at our own culture and capabilities, lots of employers offer benefits that aren't legally required. In Pennsylvania, PTO and holidays, bereavement leave, voting leave, school function leave, none of that's required in Pennsylvania. It is required in some other states, particularly as you go towards the West Coast. You will find, like Illinois, for instance, requires leave for certain school functions, stuff like that. But what we need to consider is, do we offer this even if it's not required? So one of the things that sort of impacts that decision is to know that employees rate paid time off as the second most important benefit after healthcare. So in this tight labor market, we need to be aware that paid time off is something that potential candidates are looking at and may want. And for our current employees, it's something that we can use to retain them, and if we're generous in that benefit. Health benefits, I mentioned this before, but we need to be aware that health benefits, how do we handle them on leave? Now, if you're an FMLA employer, you know that there's certain requirements to keep them going on leave and to tell employees how we're going to handle the health benefits while they're on FMLA. But if you're a non-FMLA employer or you have a non-FMLA leave, you have to think about COBRA. And COBRA usually kicks in with 20 or more employees. But you need to think about, are we going to allow them to what we call hang on the benefits? That's a really technical term, but it's accurate. Do we let them out on a personal leave and then allow our health plan to continue? Maybe we require them to pay their portion of the health insurance benefits. Maybe we don't. The biggest thing, and I cannot stress this enough, and I've talked about in other seminars, but it's worth revisiting. You have to know the terms of your health plan and how your health insurer feels or what they require about allowing employees to hang on the benefits whenever there's not a legal obligation to do so, such as under the FMLA. So the worst case scenario that you can have as an employer is you let somebody out on some type of leave and you let them hang on to the benefits rather than COBRAing them because you feel sorry for them for one reason or another, or you're just trying to be a nice employer or whatever it might be. And that person or a person in their family who's on the plan has a catastrophic injury. If they just have a tiny little boo-boo and get stitches, the health insurer is never going to look at this. But if they have that catastrophic claim, that is, the $6 or $7 figure claim, the health insurer will look at this and they'll say, well, why in the world was this person on your health plan as an active employee or an active employee's family member whenever the employee was not active? They were out on some type of leave that did not require the continuation of these benefits. And maybe they've been out on that leave for 2, 3, 4 months, whatever it is. Why did you not COBRA them? And the worst case scenario is the health insurer takes the position that shame on you for allowing them to remain as an active employee. You have essentially committed fraud by saying they were an active employee when they were not, and the health insurer will not cover the claim. On the other hand, you have an employee who thought they were covered for this claim because you never told them otherwise, and you are the fiduciary and the administrator of this plan, the health plan, and they thought they'd be covered for their $1 million claim. And now the health insurer is saying, no, they're not, because you should have offered COBRA, or you should have terminated their active status as a participant in the plan, or whatever it is. And you know who they look to for payment? The employer. So all of a sudden you have inadvertently self-insured for a huge claim because you didn't handle the health benefits correctly. So one of the big, I hope, takeaways from this is as you consider health insurance, particularly when we're in a non-FMLA situation and we're looking at a long leave. I don't mean the person goes on vacation for a week. I mean, the person is out because of, we've offered a medical leave because we're a tiny, 25-person employer and we still want to be compassionate, and the person's out for 3 or 4 months. What does our health plan say? What will our insurer tolerate or not tolerate, so that we know how to handle that type of benefit when the person is out? And it's not one size fits all. Different insurers will look at things differently, and you need to approach them before, hopefully, the person's out a long time. Because if you're approaching them while the person's out, they're going to, all sorts of little red flags are going to go up in the insurer's mind. We want to be proactive. We want to be able to set the expectations of our employees so they know whether they're going to get health coverage, whether they're going to be COBRA'd. If so, at what point during the leave will they be COBRA'd, et cetera. Okay, and again, when we look at certain things like California and other states, just because Pennsylvania doesn't require that we carry on the health benefits in certain situations, other states do. And remember, we've talked about this in other seminars too, it's where the employee is located that will often drive what we need to offer in terms of health benefits. And so our health insurance carrier also needs to be aware if we have employees in Idaho or wherever it might be, because they need to know what is going on in terms of where our employees are located, so that we don't have some sort of issue that Idaho, and I'm sort of just making that up, I'm picking on Idaho right at the moment. Idaho requires us to continue workers or to continue health benefits during a leave or workers' comp or whatever it might be, but Pennsylvania doesn't, and our health insurer thought we were just in Pennsylvania. So very important to have an open line of communication with your health insurer, not just with your broker or insurance agent, because sometimes they don't appreciate the nuances here. We need to make sure that we have an open line with our carrier and know what their requirements are. Okay. Moving on, policies, right? This should go without saying, but I really want to touch on this because there's two really critical points here. We want a written policy that addresses each type of leave that we have either decided to voluntarily provide, like PTO or bereavement or whatever it is, as well as any leaves that we're legally required to provide. Now, we did a seminar on handbooks a while ago, and we talked about a canned handbook, one that you just pull off the internet or you get for $15 or whatever it is. A canned handbook is typically better than no handbook at all and can be very useful for small employers who don't have the resources to invest in a tailor-made handbook for their company. It makes sense. It makes a lot of sense. But you have to be thoughtful about them as well. And so in the handbook seminar, I talked about the fact that I have seen canned handbooks where clearly nobody in the employer ever cracked it open and read it, but they were passing it out to employees and they had blanks in them. You know, insert name of person or name title, and it was still in brackets, and it said insert name of person, or it said insert name of state where employer is located, and that's still in brackets. That looks terrible if you get sued and you haven't even filled in the blanks in your canned handbook. And unfortunately, employers get busy. The handbook's not a real priority sometimes, especially for smaller employers, but please fill in the blanks. If you get sued for whatever reason, whether it's discrimination or FLSA violations or leave issues, to have a handbook that doesn't have the filled in the blanks is a problem. The other reason that, especially as you get larger, you want to think about at least having certain sections of the handbook tailor-made to you is if you are in the city of Pittsburgh or Allegheny County, for instance, or you have employees in other states, you want to make sure you're addressing those leave laws. Not only is it required, right, that we say something about them, but the handbooks can actually be contrary, these canned handbooks, to what is required under Allegheny County or Pittsburgh or wherever you might be in this country. There are leave laws. And so while a canned handbook can be very, very useful, one of the provisions that often trips you up is the leave section, because it doesn't match up with what your practices are in terms of either voluntary benefits or legally required benefits. The other thing that it can do is it can contain provisions that you are not subject to. So I'm assuming you're a very small employer, under 50, if you are using a canned handbook, because by the time you have 50 to 100 employees, we should be migrating to a tailored handbook because we're large enough to be covered by every federal law out there with respect to labor and employment. Sometimes the canned handbooks come with provisions that aren't applicable to you, like the FMLA. If you have 20 employees and you're in Pennsylvania, the FMLA doesn't cover you. If you have an FMLA provision in your handbook and you're not an FMLA employer, the courts generally take the position that, well, hell, hey, you voluntarily adopted the FMLA policy in your handbook, so you must want to offer that benefit to your employees. So even though you're not legally required to do so, you have voluntarily opted to do so based on your handbook, and therefore we're going to hold you to it. That's a bad position to be in as an employer, because it gives you less flexibility and obligates you to something that has a lot of hoops to jump through, as your colleagues who have 50 or more employees can tell you, that you otherwise would not be obligated to do. That's not to say you wouldn't give some sort of leave, but you wouldn't have all the bells and whistles associated with FMLA. So be very careful about the canned handbook and what it says about any type of leave, whether that's PTO, voting leave, bereavement leave, leaves of absence for a health condition or a disability, whatever it might be. Be clear about how this accrues and whether or not you have use it or lose it provision, particularly for the voluntary types of leave. Certain states like California, they have unique things on a lot of things, but more and more states are moving in this direction. You have to allow it to accrue, and you are prohibited from having a use it or lose it provision. So if you have employees in other states, you need to be cognizant of those states' laws regarding use it or lose it provisions and how it occurs. And even if you're not in one of those states that has those fund provisions, you also need to think about how having provisions like that influences your workforce. Does that mean that everybody at the beginning of the year has a zero bank? And if somebody has a zero bank of time, what are they going to do if they have, if they catch COVID, for instance, or whatever it might be? If they have a use it or lose it provision, you're going to guide your employees or inadvertently guide them to using all their time all of the time. Do you pay it out when they leave? In Pennsylvania, you don't have to, but in California, you do. So you need to be thoughtful about those provisions, both what state you're in, as well as the fact that if you don't pay it out when they leave, you encourage your employees to use it. And that can be a good thing because people need time off while they're employed. You need to know the forms needed, and we'll talk about that a little bit more, and the time period for submitting those, particularly if you're an FMLA employer. However, if you're like in Allegheny County, you can't enforce the use of forms. So you also need to be aware of that. Very importantly, you need in your canned handbook or in your tailor-made handbook to say who is in charge of the leave. Because otherwise, you have people going to their frontline manager, and we've talked about frontline supervisors before and the liability that they inadvertently create for employers. And you have little Ann going up and saying, hey, I'm going to have back surgery. I'm going to be off for 6 weeks or whatever it might be. And that person may not be running it up the chain of command. They may not be appreciating what Ann is saying. I always pick on myself, and how that affects a decision about health insurance or the need for leave or whatever it is. You want to put your employees on notice in the handbook that they should be going to whatever, and usually I put in a generic title, the VP of HR, the HR manager, the owner, whoever it is. We don't have to have a specific name, but we want a title so that we tell them this is who you're going to. And if that person, the reason we put in a title is if that person leaves, we've got a title in our handbook and we don't have to change it every time the HR manager leaves or whatever it might be. The other really critical thing that you need in your handbook about leaves that doesn't often happen in a canned handbook is to explain how leaves run concurrently from an employer perspective. You want certain leaves to run concurrently. You're not trying to provide tons of time off, especially if it's paid time or time that they're on your benefits. So if, for instance, you are in the city of Pittsburgh and in Allegheny County, obviously, and you're an FMLA employer, we don't want a situation where we say, okay, first you use the city of Pittsburgh time bank, then you use the Allegheny County time bank, and then after that, you can have the FMLA. That would give the person much more time than they're legally entitled to. And it puts you at a disadvantage. You want time, assuming you can run it concurrently. If we have like the employee's own health condition, you want to run that concurrently with the city of Pittsburgh, the Allegheny County, and the FMLA all at the same time. And we want to make that clear in our handbook that we are doing that. Even if you're a non-FMLA employer, we want to make it clear that maybe we're running Allegheny County and the city of Pittsburgh and your PTO all at the same time, whatever benefits we may have out there, that you're not going to just double dip and say, okay, I've got, X number of days of this leave, X number of days of this leave, and X number of days of that leave, and I don't have to run them concurrently. I'm going to run them consecutively. That is not the intent of these laws, and that's not how our handbook should read either. We should be crystal clear that we are running these concurrently in most situations, because in most situations that's going to be permissible. Okay, moving along, communicate. This is ethically appropriate as well as legally appropriate. We want to make sure the employees know. Unfortunately, when employees get fired, they also sometimes get amnesia and don't seem to remember anything that we've told them. So in our handbook where we told them who to go to and they went to the wrong person, we want to be able to establish that. So we have a handbook that's appropriately drafted. We have a handbook acknowledgement. That's the right ethical thing to do. And it's the right defensive tactic for us as well as an employer to be able to prove that we gave them the right information at the right time. When you have non-specific canned handbooks, this can be a problem, not only for the employees, but HR and the frontline managers. And you want to track it, the time off in a way for everybody to see. You can do that through like CTR's payroll system. But however you track it, you want people to be able to know where they stand with their leaves and how much FMLA have they used. Do they have a bank of time under the Allegheny County sick leave laws? And again, we've done a seminar on those. So if you're looking for the nitty gritty information about those, you can check back on the CTR website. Let's take a moment here and talk about FMLA leave, because I know a lot of you online today are covered by it. You're typically 50 or more employees. If you're a government employer, that number is much smaller as to when coverage starts. But the government has given you a gift. How often can you say the government has given you a gift? And that are these canned forms that you all should be using. I'm going to assume that most of you are using these, but just to be clear, we have WH 380 and there's two different forms, E and F under there. If you just Google that, you will find them. And those are certification of healthcare provider for either the employee or the family member at issue. We have 384 and 385, which deal with military leave or qualifying exigencies, if that ever comes up. And that's a little bit more rare. But if that comes up, there's forms for it. This is the gift from the government to you to use these forms. And if you use them, you know the government can't complain about what you did in an investigation because you used their form. And then we have 381. A lot of employers miss this form. This form, if somebody approaches you and says, hey, I'm suffering from back pain and I'm going to need some time off. And my doctor recommended that I take 2 weeks off to rest my back and go to PT and whatever else. At that point, they have triggered a notice provision on our end, assuming that we're an FMLA employer. And we have to give them the notice form 381 of their eligibility and rights within 5 business days of us knowing about the problem. And under the FMLA and the interpretive cases and guidance, us knowing about the problem is very broadly interpreted. We have to have enough knowledge to put us on notice. And if we haven't been clear about who they should go talk to for leaves, if they just tell their supervisor who may or may not appreciate the significance of this, they've put us on notice. So we need to be thoughtful about that. We have 5 business days to give this form to the employee to tell them, hey, whether they're even eligible or not. Because remember, they have to work 12 months, not necessarily consecutively. They have to work 1,250 hours. Are they even eligible for FMLA leave? And if they aren't, then we have to think about other types of leave that we may provide to them. Once we get the certification of healthcare provider back or one of the other forms back, if we're dealing with a military leave, we then give them a designation notice under the FMLA that has to be done within 5 business days as well. That's form WH 382. Very critical when you look at this form as an employer. This is your big shot. This is your one bite of the apple. That if there's something about that form that is incomplete or insufficient, or you question this in any way, shape, and form, this is when you question it. And you have to give the person at least 7 days to correct the incomplete or insufficient certification. And so if we have blanks on there or information that doesn't make sense or just says, I don't know, and you would be surprised at how many certifications come back that say, I don't know, or undetermined, or something like that, that the doctor has put on there, This is our opportunity to say, no, you have to clarify it a little bit for us. Give us an educated opinion on how long the person's going to be out, not just, I don't know. This is our opportunity to give the form back to the employee and say, hey, you need to get this clarified with the doctor. We have to give them at least 7 days. Oftentimes we have to give them longer if they come up with even a plausible reason as to why they're having problems giving us the form back within 7 days. You know, the doctor's on vacation, the doctor's busy, whatever reason they may have. It's also our opportunity to ask for a second or third opinion. So those opinions, and we talked about them in the FMLA seminar, they're at our expense as the employer. It cannot be with somebody who's regularly employed by us, such as a workers' comp panel physician. One of the interesting things there, though, is if the employer's physician fails to provide the relevant medical evidence to our physician in a second opinion, that actually gives us a reason to deny the leave. Now, again, it has to be relevant information that we're missing that our doctor cannot make an informed decision on because of the employee's doctor's failure to give the information to our doctor. Okay, we also, when we get to the third provider, we have to mutually agree with the employee as to who it's going to be. That can be very, very, very difficult. So by the time you're in the second and third opinion realm, you probably should have legal counsel being your quarterback as to how that works, because there's a lot of things that can go wrong, and you just need to have a sounding board to make sure that you're doing that correctly. Oftentimes I got asked the question, can I tweak these FMLA forms? I'd like to ask some more questions, or I'd like to put this, that, or the next thing on it. Generally, I shy away from that. I'm sorry, we went too far. Generally, I shy away from that. These are what the government thinks is appropriate. They are the ones who do the investigations. If there's an issue, use their forms. If you need more information for some reason, think about the incomplete or insufficient certification issue. That is your best bet. Should you use an outside consultant or leave administrator? Well, that really depends. That's a question that comes up quite frequently. If you use them, you're using them because you don't have either the in-house expertise available to do this, and that may be true if you're just over the 50 mark. If you have a couple hundred employees, hopefully you do have the in-house expertise. They may be too busy. That's another reason to do this. Or you may just not want to know the medical information because you're trying to build up sort of a Chinese wall to say, if Anne needs to leave, I'm going to point her in the direction of whatever administrator we've chosen, so that I don't know this. So that if I make future employment decisions about Anne, she can't come back and say, well, you knew I had a back problem, or you knew I had XYZ. I may have none of that information. The one thing you should be aware, though, is the ultimate liability. And sometimes the ultimate decision-making on close calls is left with you as the employer. So if your leave administrator mucks it up, you are ultimately liable. And you may be able to go back and try to sue the leave administrator to indemnify you, depending on what your agreement with them says. And oftentimes those agreements are very one-sided, in their favor and not in your favor. But you ultimately retain the legal liability for that. You retain the problem if there's an investigation. And in FMLA situations, there's personal liability for those involved in the decision-making process within the employer. So you retain that liability as well. Can you or should you use these for non-FMLA leave? Probably not. These forms have certain rights on them, and things like healthcare, how we're going to do that, that wouldn't be applicable for just a voluntary leave of absence that we're providing, either because somebody has an ADA issue, or we're just good guys and we provide leave in certain situations. Hopefully we've spelled that out in our handbook. So typically, no, you would not use these for an FMLA, non-FMLA situation. Okay. Moving along You want to set the parameters for non-FMLA leave, typically PTO, bereavement, workers' comp, local leave laws, etc. You can and usually should have some type of written request that you require if somebody wants a non-FMLA leave or some way to get that into your system. One of the nice parts of that, from my perspective, from a defensive perspective, is if I get Ann on record as saying what she needs and what her issue is, if I terminate her later and she says, well, something completely contrary to what was in the original request, Ann will have a credibility problem as an employee. Now, there's some limitations to that. For instance, in Allegheny County, we can't require, if they're using paid sick leave law under Allegheny County, we can't require them to put down the reason in writing as to what my medical problem is. I just, in certain situations where the leave is more than 3 days, I can require the employee to get a note from a doctor, but I can't require them to put any information other than, hey, Ann needs a leave of absence, sign the doctor. So do be aware of limitations. But if you're not under a limitation like that, then yes, we ought to be keeping track of this. We ought to be recording why the leave is occurring for some reason, especially if we're looking at a longer personal or medical leave. All right, moving along. So let's hit some of the real life situations, and I welcome participation here. So if you have some thoughts about how you would handle this, whether you just let's terminate everybody and move to Hawaii, or whether you are going to accommodate everybody, let me know. So an employee in the probationary period, I've called her Susie. She's sick a lot. She keeps missing time, even though our policy says no time off during the probationary period. Why do we have that policy? Because we're trying to make sure that the person is reliable, and presumably they're going to put their best foot forward during the probationary period. Is this policy, let's stop right there. Is this policy, we have a good rationale for it, right? We want to make sure the person's reliable. We're testing them out during the probationary period. Is this policy legal? Anybody want to raise their hand on Zoom here? I so wish that we were in person and could do this. But is this policy legal? I think some people are playing along, and I appreciate that. Yes, with the caveat that our policy should have weasel language in it. All attorneys like weasel language. It should say unless otherwise legally required. And here is where the unless otherwise legally required comes in, and why you should look at your canned handbook to see what it says. So yes, we have a legitimate business reason to say, hey, new employee, you need to work during your probationary period so we can see how good or bad you are. And if you're calling off just because your car doesn't work, or your kid is sick, unless we're covered by a law that would protect that, or you overslept your alarm clock, or just wanted to go golfing that day, none of that is protected, and we should terminate. Really, if they can't make it during the probationary period, we should terminate. But the part that is unless otherwise legally required is, are we under some local law that's going to give them time almost immediately? Or more likely, do we have a disability going? Because the disability laws, whether we're looking at the ADA or the Pennsylvania Human Relations Act, which kicks in with 4 or more employees, doesn't care if we're in a probationary period or not. They will question whether or not we could accommodate that person regardless of probationary status or not. So let's move forward here. What was Susie off for? So she racks up 3 absences. Enough is enough. We were desperate for employees. We kept her on, but now we call her into HR to terminate her because, gosh, 3 absences and you're not even done with your probationary period is a problem, no matter how desperate we are for employees. And her response when we tell her she's done is, thanks a lot. I thought you'd be more understanding. My manager, my first level supervisor, never told me this was a problem. Do we have issues here? Of course we do, or else we wouldn't be talking about this, and it wouldn't have landed in my lap many years ago. So again, first line supervisor had information and knowledge that the absences were due to migraines and didn't run it up the flagpole. He didn't tell, or she didn't tell the right person. They didn't give us a chance in HR to make an informed decision about these absences, and instead we moved straight to termination. That's our first issue. Are migraines a disability? Probably. They are a difficult disability to deal with. It's just like back pain. You can't see it. People can abuse it. We hope they don't, but they can. And yet the law is going to say we probably have a disability, because the definition of disability is pretty broad. And even though we are not an FMLA employer, and even if we were, she wouldn't be covered by it because she doesn't have enough time or hours or anything else in, we have to look at whether or not periodic absences due to migraines, which are arguably a disability, are a reasonable accommodation to provide, even if it's in the probationary period. That is going to be fact specific. We can look at, first of all, we should be getting medical information from her to substantiate this and to substantiate how often she might need time off from migraine. Is it once a month? That's a very different scenario than twice a week. Once a month might be much easier for us to accommodate than twice a week. Are there other accommodations that might work? Maybe she wakes up with this, but once she takes her medicine, she's good as gold 2 hours later. You don't know. So we should have gone down that path. In an ideal world, I got asked this question. I don't practice anymore, but I got asked this question a lot. What if I've just pulled the trigger on whether it's discipline or a termination and somebody says something like this? In that situation, what I would say is this stands pending our review. And our review is going to include, did she really tell her manager? She may be making that up. I hope not, but it's possible. We want to give ourselves a chance to reverse course on the discipline or the termination if we think we have just violated the law. And so what we want to say is, look, give us 24 or 48 hours. We're going to review this. We'll either reverse the discipline or it will stand depending on what we find out, or same thing with the termination, pending our decision when we look into this. And maybe our discussion with legal counsel when we look into this, if we say, gosh, what do you think? Is the condition they've just said a disability? Can we accommodate that? Can we not accommodate it? It will depend on their job too. The person who answers our phones can't really work from home, and it's a problem if they're off all the time. Other positions, it might not be an issue. In fact, there is a case involving Walmart. Now, obviously, we are not the Walmarts of the world, but the person wanted a leave of absence that extended past 2 years. And Walmart eventually terminated the person, which I would have said that was reasonable. The court, however, said, no, Walmart, you are so big, you always need people to work in your stores. You could have a 2-year leave of absence is completely reasonable. Now, smaller employers, obviously that's not true, but that is the thought process out there, is what is reasonable. One of the things that we look to as to whether or not something is reasonable is what we do with other coworkers that are similarly situated. So does it matter that you just granted a personal non-medical leave to Susie's coworker as she deals with details from her mom's recent passing? So let's say Susie and her coworker have basically the exact same job. We have just shown that we can accommodate a leave. And in this case, the court will look at the non-medical voluntary leave as less important than the migraine, possibly disability leave that we didn't do anything with and should have done something with. So we want to look at what we're doing with other coworkers in terms of How do we accommodate other coworkers? And one of the things you will run into is it may turn out that the coworker is our star employee. She's just great. We want to do anything we can to retain her, but the court doesn't care who the star employee is and who isn't. Neither do the investigating agencies. They will just say, well, gosh, you could do this for the star employee, the coworker, for a non-mandatory, non-required leave, but you won't do this for somebody who has a disability? That puts you at a significant disadvantage. And I'm certainly not saying don't offer the leave to the coworker, but know that when you do, you have set a precedent that you can accommodate these sort of things. Same thing if the coworker wanted to work from home. If they're in the same position, you have to be able to defend why that wouldn't be a reasonable accommodation for Susie. And that's going to be a really, really difficult defense to say, hey, yes, we offered it to the coworker, but not to Susie. Okay, moving along to our next scenario. This unfortunately was a real situation as well. Joe is a 20-some year employee. In fact, if my recollection is correct, when I handled this, he was closer to 30 years for the same company. Flawless record, great employee. He fell and broke his leg at work. It was a severe break, not just, I'm going to wear a cast, but this required surgery. It required all sorts of stuff. He was an older gentleman at the time. He worked in a job that required standing and walking and moving around. Obviously, he can't do that on a severely broken leg. And what made matters worse is he developed MRSA, supposedly, and perhaps truthfully, because of the hospital when they operated on him and when he was in there. And what was initially a 6 to 8 weeks off of work turned into a nightmare for him. And he had a bunch of follow-up surgeries, bunch of procedures. He kept asking for more and more time, which the employer kept granting because he's a great employee. He's been with us almost 30 years. He's done everything we've ever asked him to do. We like to have him back. But gosh, he's been up 9 months now. What do we do? What's one of the first issues we see? Anybody want to play along and put something in the chat or the Q&A as to the issues they see here? Or do we all think we should just fire him? Come on, folks. Again, this is when I wish we were live because it's so much easier to have a discussion. Okay, great. Somebody is playing along. Workers' comp. Yes, thank you. Thank you, workers' comp. That's the first issue here. Thank you, thank you, thank you. Workers' comp, this is a work-related injury. So when we talk about leaves running concurrently, and this was an FMLA employer too, by the way, this was a large company. What do we do? The first thing should be he's on workers' comp. We should be working with the insurance carrier, or if we're self-funded for workers' comp with our third-party administrator, to get this guy back to work if we can. And we should think about the workers' comp implications if we don't get him back to work. So one of the takeaways here, no matter what size company you have, if you have somebody who's out on workers' comp and you ultimately decide that you cannot keep their position open and you terminate them, that has a consequence for workers' comp. They now have no job to return to because you have fired them. And firing them might be the right decision. But you need to make that decision knowing that your workers' comp liability has just increased because there's no job for the carrier or the TPA to return the person to. What does that mean? If we can't return them to the pre-injury wage at their pre-injury job or something similar here, we have a problem because now the workers' comp carrier has to look and say, well, we're either going to settle this out via compromise and release agreement, or we're going to try to find him a job somewhere else, which doesn't usually go over well and has all sorts of problems with it. We have increased our liability and how long this person might be on workers' comp. And that may be okay with us. We don't run in fear of our workers' comp. We have that insurance for a reason, but it factors into our decision making. At the same time, because this was an FMLA employer, while you run workers' comp, what else do you run? FMLA, they run concurrently. And we don't want to be in a situation where this person has been out on workers' comp for 9 months and we've never sent them the FMLA paperwork. Because that person now has an argument if we've never sent the FMLA paperwork to say, I didn't know you were running this concurrently. The handbook doesn't say it, your nice canned handbook that you forgot to fill in the blanks. And I had no idea. And I thought I'd still have those 12 FMLA weeks left. That argument, while you might roll your eyes at it and say, oh, who would think that in their right mind, comes up more often than you would believe. Because the person is desperate for more time off. They want to maintain their job in most cases. And they may genuinely have been confused if your handbook wasn't clear. They may have really thought that time was still theirs. It comes up even more so when you have a situation where the person's been out, like, let's say 6 months, and they come back and they think they still have their FMLA time for doctor's appointments or to take care of their sick kid or whatever it is that they've got going on. You need to run it concurrently. If the leave is also a leave that would qualify under a local law like Allegheny County or City of Pittsburgh or wherever you might be, you want to run that concurrently and you want to put that person on notice of that. You also want to be clear in your PTO as to whether that's going to run concurrently with any of these types of leaves. You can or you can't, but you need to be clear as to what's happening so that the person doesn't think they're coming back to a 3-week bank of PTO if they've been out 6 months, if that was not your intent. I will say, on some of these leaves, when we talk about running things concurrently, particularly the PTO, when you get a leave of absence, let's say you have a lady who's out on maternity leave, and our next example does deal with maternity. She's out for the full 12 weeks of FMLA. If we require her to run her full 3 weeks of PTO at the same time, and I'm using those numbers as examples, and then she returns, let's say the leave started January 2nd. She returns at the end of March, roughly. Now she has no time off, no paid time off for the rest of the year, and she's got a newborn. And anybody who's had to deal with a newborn knows that they can get sick and they can have other issues and they go to the doctor a lot. You have maybe put that person at a real disadvantage by doing that. And so oftentimes what we would recommend, and you don't have to, this is just a thought, we will have the person burn through 3/4 of their PTO or a certain amount and leave them with a couple of days so that in a scenario like that, when they get back, they might still have a couple of days, but not 3 weeks of PTO. So something to think about. Can we or should we terminate this person who has a really tug at your heartstrings type of problem here going? He's been a great employee. Ultimately, this employer let him out for a month and then terminated him because there was no sign of this person being able to return to work. And that becomes key because, just asking for an extension after an extension after an extension of leave, at some point that becomes an indefinite leave of absence and termination is appropriate. They did terminate this individual after 12 months. Note right there, they have set an interesting precedent for the next person who comes along, that they are willing to do a 12-month leave of absence in this particular job category. He turned around and sued for disability discrimination. That's how we got involved. Ultimately, the court found in favor of this employer and said, hey, for this size of employer, and given the medical information that this person may never return, it was really iffy. This was an appropriate leave. Any additional leave would be an undue burden on the employer and not a reasonable accommodation. Okay, somebody has asked, and I appreciate this question, does the employer who grants FMLA to an employee receive any benefit? No, you're not really receiving a benefit other than you're complying with the law. If you are a non-FMLA employer, meaning you're too small, most non-FMLA employers have some type of extended leave for certain medical situations built into their handbook. Because let's say you have 25 employees. First of all, if you're in Allegheny County or City of Pittsburgh, you should have that built into your handbook. But it comes up. People have babies. That's the most common one, right? Do you want to fire everybody who's going to be off 6 weeks because they've had a baby? That's probably problematic and not the culture you want. People have medical issues. People break legs. People have small surgeries. If you have 25 employees, most companies would want to provide some type of benefit. It doesn't have to be paid. You can just say, hey, you need 3 weeks off because you have hernia surgery or whatever it is. We want you as an employee. We're going to give that time off to you as an unpaid leave. So most non-FMLA employers will have some type of short personal leave built in. And that's where you need to check with your insurer as well, your health insurer, because you want to know what their position is if you start offering these leaves that are maybe 2 months long. How do they feel about a leave like that, and whether or not the person can hang on the benefits? Okay, another great question. What if the employer provides LTD, long-term disability? That is fine, but that is a separate issue from whether we keep this person on or not. In this particular case, the employee was on LTD, right? Long-term disability. He went through short-term disability, which again, we're running these things concurrently. We've got him on workers' comp. We've got him running his FMLA time. This employer was actually doing it right, with the possible exception that they have set a really interesting precedent that this person's off for 12 months on LTD. That's nice. And that's a great benefit to offer employees, especially somebody like this. But that doesn't necessarily play into our decision of whether or not we keep this person. Now, if in the LTD paperwork, the person has said, I can never return to work ever, 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 that may give us a great basis for terminating them, because they've just said they can never return to work, and this has become an indefinite leave of absence. But that in and of itself, the LTD doesn't determine what we do here. And again, let me point out one other thing, which I feel like a broken record in these seminars, but attorneys are really expensive. And I say that having practiced more than 2 decades. You do not want to be paying any attorney out of your own pocket. You want employment practices liability insurance. Feel free to raise your hand here on the Zoom thing if you've heard me say this before, because then your liability in a situation like this is your deductible and a headache of litigation. And in this case, they gave him a 12-month leave. He still turned around and sued them. He was really hurt. He had been there, almost 30 years, very upset at how they had treated him from his perspective. And, even though the employer ultimately won the lawsuit, that lawsuit is super expensive and really not something that you want to be paying on your own dime. You want to pay the deductible. You're going to have the headache of litigation. But if you are individually responsible for this claim or this lawsuit, that can influence whether or not you fire the person. You're going to feel handcuffed because you can't stop a lawsuit. You're going to feel handcuffed to settle because the cost of settlement is almost always going to be cheaper than the lawsuit. So you want to be able to make employment decisions without feeling handcuffed. Thank you for those questions. Great questions. Let me move along to our last example, and then I'm happy to stay on longer if people have other questions, but I know we're running close on time here, and I want to be respectful of everybody's time. So we have Jack and Jill. I have kids. I named them after a nursery rhyme. They're both your employees, and they're having a baby. Well, let's be precise here, right? Because I've had multiple kids. Jill's having the baby, not Jack. Want to give her credit for that. Jill lands in the hospital with preeclampsia and will be on hospital bed rest for the remaining 4 months of her pregnancy. Jack is distraught and emotionally breaking down at work. Let's stop right there. We have an FMLA employer who has FMLA rights here. Both of them do. For multiple reasons, right? Jill clearly has her own health condition, serious health condition. So does Jack. Don't forget that emotional or psychological conditions qualify under the FMLA. He is distraught because of his wife's condition. Not surprising he's having problems like that. he has his own issues. If you have a married, or if you have a couple, they don't have to be married. If you have a couple and both parents are working, you can have special language in the FMLA when it comes to pregnancy and bonding with the child, that the two of them together, the two employees only have 12 weeks. But this is outside of that. This is their own serious health conditions. And Jack also has FMLA rights here because his wife has a serious health condition. And he could, even if he wasn't distraught, maybe he could care less, but if he wanted to take care of her, he would have FMLA rights to do that as well. So they have multiple FMLA rights, every which way you look at this, for 12 weeks for each of them, even though they are both employed by the same employer. What happens next? Jill delivers little Jay Jr. 2 months early. Jay Jr. is in the NICU, neonatal intensive care unit. Jill continues to suffer from pregnancy complications, and she's now distraught over the little baby's health condition and traumatized by everything she's been through. We've still got Jack, who is distraught. Who gets leave, if any, for what and when? If you're an FMLA employer, they both are going to qualify for, again, for multiple reasons: for the care of a child with a serious health condition, for their own serious health condition, to care for each other's serious health condition. They qualify in multiple ways. So when you have a pregnancy that is having problems, never forget that we're not just looking at the childbirth and bonding FMLA time. We are looking at their own serious health conditions or caring for their partner's serious health condition in this type of situation. So something to be very cognizant of. You also need to be thoughtful. This is a situation where the law is part of what you look at. You also look at how would a jury perceive what you have done. Part of the handbook issue is forewarned is fair warned. Nobody likes surprises. But in this type of situation, this tugs at your heartstrings, right? It's just like Joe, who's like a 20-some-year employee. We want to try to treat him right. And the jurors, who are essentially his peers, aren't going to appreciate an employer who's been a jerk. Same thing here. You have a really traumatic situation that's going on. Let's say they blow through all their FMLA time before the child's even delivered. Both of them have disabilities as well. A disability can be an emotional or psychological issue. And they may blow through all the FMLA time. You don't terminate as soon as they blow through the FMLA time. You should be sending them a letter at least 2 weeks before the FMLA is over saying, hey, your FMLA expires on blah, blah, blah date. Are you able to return? We want to help you. Let us know where things stand, because maybe they need an additional disability leave to handle their own serious health conditions beyond the FMLA. And if we are a non-FMLA employer, we need to be looking at whether or not we can accommodate their leaves and the need for leave as a disability accommodation, or any type of PTO, personal, medical, whatever we may have stuck in our handbook, and hopefully we have it well spelled out, leave plus an additional disability leave, because this will qualify under the ADA. All right, I know I have questions. I promise you I'm going to get to those. I appreciate everybody's time. And clearly I'm not hitting the right button on my computer. I appreciate you attending. For those of you who have other time commitments, thank you. We will do this seminar again. The second Thursday of the month is when we typically do them. And I welcome ideas for future seminars. I love going over case studies. So if you want to see more of those, let me know. Anything of interest, let me know as well. And I will now answer some of these questions that we have rolling in. Okay. So let me answer this one because this is a real quick answer. Could you repeat the type of insurance that protects the employer against liability? Yes. Very critical to look into this. Employer practices liability insurance. It's known as EPLI. If you have 4 or more employees, and maybe even smaller, you really ought to look at it, because when you have that insurance, it doesn't cover everything. No insurance covers everything. And in fact, if you listen to the FLSA seminar, you'll hear some of the caveats on EPLI and FLSA issues. But when we're looking at the typical things that employers could sue for, discrimination, harassment, disability discrimination, which would be this, EPLI will typically cover those types of causes of action. And then, when you're making employment decisions, that your exposure, your liability is the deductible, whatever that may be. And the deductibles are usually a little pricey under this insurance. It can be 10, 15, 25,000, but that is still something that most employers can stomach, as opposed to a lawsuit that might be $250,000 just in attorney's fees, depending on how far it goes. So you have a known quantifiable cost. If somebody sues you, that's your deductible. And then you have the headache of litigation, and it is a headache, but that's the type of insurance you should be looking at. Okay. So somebody else has said, if we have an employee that is due to reapply for FMLA, can we deny since the employee is the only registration staff member in their department? That's irrelevant. The fact that the employee may be the only person doing their job function, if they are otherwise eligible for FMLA, it doesn't matter if I'm the only person in the whole company who has that specific knowledge and can do it. The FMLA doesn't care about that. Then the question goes on to say, the employee's FMLA was approved for a specific condition, but she's been out many days beyond what's approved for other medical conditions she's experienced, but provided medical notes for. Most of these days have been taken unpaid because she's exhausted her PTO. So we've done some things right here. We've run PTO with the FMLA. Hopefully that's clear in our handbook that we can do it. When we say that she's taking other days off because of conditions that she's not approved for, we should be offering her another certification from the healthcare provider, because sometimes conditions morph, right? Initially, it started as migraines, but now I think I have a thyroid issue. She may have another FMLA qualifying condition, and we're within our rights to say, hey, Susie, you had FMLA for migraines for 30 days, and I'm just making this up. And now you want more time off because you have a thyroid issue. We give her another notice of eligibility, right? Because presumably she's still eligible. She still has the right amount of time. We're still an FMLA employer, et cetera. Here's another certification. If you want additional time off for your thyroid issue now, here you go again. We need to be documenting that. We want her on the FMLA clock to exhaust the FMLA. So then we're looking at is whether or not a disability leave extension is appropriate or not. And really that's something that you should be talking to counsel about. But that's the path you want to go down, is we just don't want them out there doing whatever. If for her additional days are just, I had the sniffles, that's not FMLA qualifying, right? An FMLA qualifying event is a serious health condition, not the sniffles, unless she has complications from the sniffles and it turns out to be COVID or something like that. And I'm not trying to make light of COVID, but those aren't FMLA qualifying conditions. And if she's missing and doesn't have PTO, that might be an opportunity to discipline. But we'd have to look at what we do for other people. Do we let other people go beyond their PTO when they have little colds or the flu or whatever it might be? So there's a lot of unknowns there that we'd want to look into, but that would be the thoughts out there. Okay. Do we have to offer FMLA leave to an employee who's hurt in an accident outside of work? If they are otherwise qualifying, they've got enough hours and you're an FMLA employer, yeah, it doesn't matter where the accident occurred. If they have a serious health condition, yeah, we offer FMLA. It doesn't matter where the accident occurred. It doesn't matter if it's a physical injury or an emotional, psychological injury. If it qualifies as a serious health condition, and we're an FMLA employer, we should be offering it. Okay, the question goes on to say, if so, when should we be offering and how far back can we go? Okay. So let's talk about that. If we are close in time, that we won't prejudice the employee by retroactively designating FMLA time, we can retroactively designate it. If this has been going on for a year and it happened back in January, I think he has an argument that we would prejudice him, especially given your next question here, by retroactively designating it. If this happened 2 weeks ago, yeah, we're behind the 8 ball. We didn't give the right forms. We should have given out that notice of eligibility, assuming he's eligible, or even if he's not, telling him he's not eligible in a timely way. But I would not have near the concern of retroactively backdating the FMLA if it's been really recent that this has occurred. You also mentioned his child was in an accident the day before. I'm not sure the day before his own problem or his accident. FMLA covers the serious health condition of a child. So he may have multiple FMLA rights here, his own serious health condition, his child's serious health condition, that certification of healthcare provider. We may want to provide both the one for the employee as well as the one for a family member, depending on what he needs this leave for. It may be a combination, maybe his own and the child. Can we be penalized for not offering this? Yes. So if you fail to offer FMLA, a number of bad things can happen. And again, you want to make sure that you are an FMLA employer, right? That's our starting point here. Are you sure you're an FMLA employer? And are you sure that this person qualifies for FMLA? They have enough hours, enough time. There's a bunch of bells and whistles that or a bunch of boxes you want to check. But yes, so the parade of evils, and we talked about this a little bit in our FMLA seminar, is there's liability to the company. There's personal liability for anybody who is involved in the FMLA decision-making or failed to do so. If we can get a U.S. Department of Labor investigation, if the person goes to the DOL and complains about our handling or mishandling of this, they can also sue us individually for an FMLA violation. So yes, there are bad things that can come if we have missed the boat on this. And let me just say that plays into whether or not we backdate this, because if our hands are particularly unclean in this and we haven't done the right things, that maybe argues for us to be a little bit more generous and not backdate this, because we don't want to raise or to motivate somebody to go file something against us if we don't have clean hands. But again, that would be something you'd really want to look at, maybe talk to legal counsel. Okay, do you pay the employee well on FMLA, or are you just holding the position? So great question. FMLA is unpaid. There is no obligation to pay them. There are obligations to continue the health insurance under certain terms, and those forms that you give the person should spell out how you're handling the health insurance when they're on leave. And that's different for different companies. You are guaranteeing essentially that their position, or one that is almost exactly like it, will be available to them when they return within 12 weeks. FMLA can be taken in a block of time. I can take it 4 weeks at a time. FMLA can be taken in very short increments. So, maybe I have some migraine condition and I just need an extra hour in the morning now and then. I can take it in a 1 hour increment. The only time that we pay people during FMLA is if we're running PTO or something like that concurrently. That might be when they get paid, but it wouldn't be because of the FMLA. It would be because of our PTO policy. All right. If we don't return them to their job, or one that is incredibly similar, then we have an issue under the FMLA. And we'd have to really have great proof as to why we couldn't return them. Note that that's different than a disability leave. A disability leave, we're not necessarily guaranteeing that we're returning them to their same position. Depending on what we view to be a reasonable accommodation, as we discuss things and engage in the interactive process with the employee, we may be looking at other positions that are more amenable to their need for time off or whatever their issue is. Okay. We have one more question here. It says, I think this is a follow-up to the other question. It's been a little over 12 weeks since the accident. We have paid his benefits since the date of injury. When or how should we terminate? We are an FMLA employer and he does qualify. So I would strongly suggest you get legal counsel on this, since it's been that long since the accident and we haven't offered FMLA. He has a great argument that you have prejudiced him by not doing that. you may want to be in a position to offer it now. And the other thing that you should look at more globally is the fact that you have continued benefits. What does your health plan say about letting somebody hang on like that whenever you had not designated this as FMLA leave? And if you designate it now, he may be out 6 months, the original 12 weeks plus 12 more weeks of FMLA, because we don't have clean hands on this. And the FMLA is going to require that we continue his health benefits pursuant to whatever we put on that form that we give to him. So it's an impossible question, unfortunately, for me to give you a definitive answer as to when you should terminate him, because I think you have a lot of liability right at the moment that warrants a call to probably counsel to work through with your specific factual circumstances. But those are the thoughts that I would have is, I don't think you have clean hands, unfortunately. I would be hesitant to backdate a whole 12 weeks. And I would look at the health plan and see how that is going to look if we start the FMLA now. Okay, I hope I have answered everybody's questions. I appreciate everybody who has hung in there this long and everybody who raised their hand or provided ideas during the little case studies. Again, anything that you want to see in the future, please let me know. And everybody take care, and we'll see you next month. Thank you.